Georgio Agamben's statement that every law is situational law underscores a critical aspect of his critique of modern sovereignty and legal systems. This idea relates closely to his discussions on the state of exception and its impact on legal norms and practices. Here's a breakdown of the implications of this statement. Implication of every law is situational law. Fluidity and contingency in legal systems, Agamben's assertion implies that laws are not static or universally applicable, but are instead contingent on specific situations and contexts. This perspective challenges the traditional view of law as a stable, unchanging framework. Instead, law becomes dynamic and adaptable, changing according to the needs and demands of particular circumstances. This adaptability can be seen as a practical necessity, allowing legal systems to address and respond to emergent issues effectively. However, it also introduces a potential for manipulation and abuse, as it may enable sovereign powers to alter legal applications to suit their agendas under the guise of addressing unique situations. Legal normalization of the state of exception. Linking back to Agamben's concept of the state of exception, the idea that every law is situational suggests that laws can be suspended or modified in exceptional circumstances. When these exceptions become normalized, the situational application of laws becomes a regular feature of governance. This normalization can undermine the rule of law by making legal exceptions the rule rather than the exception, thereby expanding sovereign power at the expense of civil liberties and rights. Impacts on rights and protections. When laws are viewed as situational, the protections they afford can become equally conditional. This conditionality can lead to situations where individuals' rights are upheld or ignored based on the political, social, or economic contexts rather than being universally respected. Agamben's critique highlights how such a legal framework can lead to the creation of bare life, where individuals are deprived of their rights and reduced to mere lives that can be manipulated, controlled, or discarded by sovereign powers. Challenge to democratic foundations. This situational view of law poses a significant challenge to the foundations of democratic governance, which is built on the principles of universal rights and the rule of law. If laws are merely situational, then the consistency and predictability needed for a stable legal and political order are compromised. This can erode trust in legal and political institutions, as the populace may view them as arbitrary or unfairly biased towards particular groups or individuals. Ethical and philosophical questions. Finally, Agamben's statement invites ethical and philosophical reflections on the nature of law and justice. It forces us to question whether laws that are inherently situational can ever be truly just, or whether they inevitably serve the interests of those who have the power to define the situation. In sum, Agamben's idea that every law is situational serves as a powerful critique of contemporary legal practices. It challenges us to think critically about the flexibility and application of laws, the potential for abuse in their situational use, and the broader implications for justice and human rights. This notion pushes the conversation towards a deeper understanding of how laws interact with power and how they can both protect and undermine the fundamental principles of a democratic society.